We invited you here today to learn more about your roles as board members and to become familiarized with ethics in government, the Sunshine Law, your role as board members, the Uniform Information Practices Act, and handling complaints. We will, or you will, be hearing from the experts on the various subject matters. We assure you that the session will be very, very informative. We want to thank you for all of your time and energy that you spend serving on the various boards and on a voluntary basis on top of that. I would also like to acknowledge and thank the staff of PVL, as they are responsible for enabling you to ensure positive outcomes for your professions, vocations, and the consuming public. Again, thank you for your attendance today. I would now like to call upon our first speaker, the Governor of the State of Hawaii, the Honorable David Y. Ige.
Aloha and good morning. Welcome to the 2019 orientation, which is being hosted by the Department of Commerce and Consumer Affairs Professional and Vocational Licensing Division. I really wanted to start by thanking each and every one of you for volunteering your time to really play an important role. I do believe that citizen engagement and participation in our government is very, very important. I know that it takes time from each and every one of you to participate in these boards and commissions. So I really wanted to start by just thanking you for volunteering your time and energy to serve on the board. I've had the privilege of appointing and nominating you to the respective positions. And I really want to, on behalf of the people of Hawaii, thank you for your commitment to serve. Serving on these boards and commissions provides an opportunity for our community to engage in a wide range of government activities. It's very important that you provide input and a voice in our government. You are influencing decisions that are important to our professions, to our vocational licensing areas, and many, many other areas. You know, we need every year about approximately 300 volunteers to serve on various boards of commissions. You represent a wide range, whether representing your profession or vocation, or serving as a public member on these boards. Each and every role is different, but it's very important. It allows us to keep our profession short and sharp and in tune with changes that are happening all across our community. And I think most importantly, you represent the people of Hawaii in ensuring that we can protect the general public from bad actors, for ensuring that our professions are timely and current, and I think most importantly, so that we can find a way to move forward together. So I just really wanted to thank Director Kat Awakuni Cologne and Deputy Director Joanne Uchida for your commitment, for engaging and talking with you, and encouraging you to volunteer on these many boards and commissions. And I just want you to know, on behalf of the people of Hawaii, I appreciate your time and energy in making our community better. Aloha and mahalo.
Good morning. I'm Kat Awakuni Cologne. I'm the director of the department. It's my honor and privilege to welcome you this morning. I'd like to thank the governor for his time. Our PVL team, our Professional Vocational Licensing Division team, they were all scrambling the last few weeks trying to put together all of these details for you. We take this commitment to serve you very seriously, and so we wanted to provide as much good information as we can to help support you in your role as you seek to protect all of the various members of the public in your roles. I'd also like to thank the legislature. They allowed us to use their auditorium, and they also participated in the process of vetting you as well. Olelo, who is also a DCCA partner. And then I'd like to thank you for your commitment. I know it's a lot of time and energy that you're devoting to us and to the people that we serve. And so, again, we take that very seriously, and we are very appreciative of all of the long hours that you put in. And I don't know if everybody understands the amount of time that we really are requesting of you. Some boards are meeting multiple times a month for hours at a time, and so we really appreciate all of that time that you are giving to us. I did want to highlight a couple of things in the folders that we've given to you. There's DHER's policy against discrimination and harassment, and also DCCA's action plan, also dealing with the same subject matter. So even though you're not employees of the state, you are going to be coming onto our premises. You are going to be interacting with each other. You are going to be interacting with our teams. And so we want to make it clear exactly what the expectations are. We would like you to treat each other with courtesy and respect. We would like you to also treat our employees and the members of the public who come before you with courtesy and respect as well. And so we hold, I guess, you to the same standards that we are going to be holding our employees. And so we wanted to make that clear by providing that information. We've also reached out to the State Department of Human Resources Development to request that they provide training for you along these lines as well. And so because it's such a large topic, we weren't able to cram it all into one morning session, but they've agreed that they will allow us to use the Employees on-Demand training system for you as well. And so we'll be providing your contact information to DHER so that you can log on and review these on-demand training courses as well. So again, you will be very familiar with our policies and therefore more aware of what our expectations of you are in terms of meeting that minimum level of respect and courtesy to one another and to members of the public as well. And then finally, I've kind of at a late hour included something from California's Department of Consumer Affairs. And so it's just a handout either that the team provided to you just this morning, or we're going to include in the folders as well. It's the 10 principles for highly effective board members. And so I won't read them to you, but do know that as, especially Joanna and I were reading through, a lot of this really did resonate with us, including the number one bullet point, which was protection of the public shall be the highest priority for the board members in exercising their board's licensing, regulatory, and disciplinary functions. So again, we're asking a lot of you in that we're asking you to put aside your hats as industry members or public members and really to look out for the public and for the consumers and ensure that they are protected in doing all of your work. And so again, I wanted to thank you so much for all of your time and for your attendance today. Aloha.
Hello, my name is Brian Yee. I am the Deputy Attorney General with the Attorney General's Office. This is almost like school. I see everyone in the back and all the smart kids in the front. But I was with all of you. I even see my cousin, Wes. So hello, Wes. I wanted to welcome you to state government. Welcome to state government. I've been doing this for 29 years. Before that, I was in private practice and then a law clerk at federal court. But I have to say, I really love my job. And I love it because it is, for the most part, a fulfilling experience. And I really think this can be for you, too. So thank you and welcome. There are 25 boards, I think perhaps soon to be 26, that DCCA itself covers. There are many other boards throughout the state. And boards are really important to state government because we've made the decision to include citizens in the actual decision-making process. So it's not just you provide input, you actually are part of the, you actually make the decisions on behalf of the state government. And we do that deliberately to include citizen input and involvement in this process because we don't want everything to be done by state employees. So, you know, we can't do this without you. You are important both to introduce a community voice as well as to protect the consumers. And who better to know how consumers need to be protected than both members of the public or consumers themselves, as well as members of the industry who know how everything works. As part of that thank you, I want to tell you about your defenses, immunities, and indemnification provisions that we provide. And we provide more for board members than we do for state employees. We value you even higher than we value me. First, if you are ever sued for any matter in the course and scope of your employment, the Attorney General's office provides the legal counsel. You don't have to go out and hire someone. You may. You can. You could spend your own money to do so. But we'll do a good job, and we will do it for free. Second, with respect to immunity, if you are sued, there's a very high standard for a successful lawsuit against a board or commissioner. That board or commission individually, they could perhaps sue the state of Hawaii and ask for the state's money. But if they sue you individually, they cannot successfully sue unless they can demonstrate that you acted with a malicious or improper purpose. That's a very high standard. It's more than just they made a mistake. It's more than they were, you know, they didn't know what they were doing or you know, there was no reason for what they did. They have to go beyond that and demonstrate a malicious or improper purpose. It's a difficult thing to do. I can't say it never happens, but it hasn't happened while I've been supervising the deputies, advising all of you, which leads me to the issue of you're going to be hearing from the Ethics Commission, and you will have deputy attorney generals at your deputy attorneys general at your meetings. Remember to ask them the question, and remember to listen to what they say. Because if there is a vulnerability, it probably occurs if you do something in which there is a conflict. So if you have a competitor and you decide, I'm going to take away their license because I really hate them, that creates a potential problem. Please don't do that. We have, you know, in the shades of gray, we will have people to advise you as to what is or isn't appropriate. Please feel free to ask. We are there for you. And similarly, even if you are successfully sued or if there is a settlement, the state, by law, says that we will pay for that judgment as long as you didn't act with an improper or malicious purpose. And so if there's a settlement, for example, the state will generally pay for the money because the state, if we've represented you, we've probably determined that you have not acted with a malicious or improper purpose, and so your house is safe. So it's not a complete absolute immunity, perhaps, but as long as you act within a certain very wide range of conduct, and you act basically with good faith, and I think all of you at least know what good faith means to you. I think that's something that the average individual could understand. I think whatever sacrifices you make in coming and providing your services, your house is not going to be one of them. Let me move on. The proper role of the Attorney General. So we provide a deputy at each one of your meetings. If you have a meeting, there should be a Deputy Attorney General there. Not because we know your industry, not because we know your field necessarily, although I will say some of our deputies have been working for particular boards for decades, so they have a certain reservoir of information, but we are not there to tell you how to do your job. We are there to help you and guide you through the limitations and parameters of working within state government. So we have a multiple series of roles. First of all, we're the attorney for the state. We're not the attorney for you individually, but we are the attorney for you as a member of the board. So if you as a board member have questions, we will answer them. If you want to tell me what your neighbor's doing, building their tree, and it's going across your yard, I'm not actually your attorney for that, but I mean, I might give you some advice, but I can't do that as your attorney. So I can't help you if you've had your wife had an accident. I can't help you if your neighbor is playing the radio late at night. But I can certainly help you if you want to know what the Sunshine Law requires, what ethical rules exist, what the rules and statutes for your particular industry are, which are really going to be the probable questions you're going to have for us. So we are available to answer any of those questions. We have multiple roles as well between our role as an advisor and our role as an advocate. So once you get sued, or once the board gets sued, we are the advocate. We are protecting and defending the state, and we are advocating on their behalf. Separate from that, however, we're also the advisor, and that's probably the role that you will see us most in. That is, we will be at the meeting, you'll want to know which way you should go, and you have some question about some legal question. And we will tell you what the pros and cons are, what the risks are. We might tell you alternatives that you could follow. So in that role, we are not telling you your ultimate outcome generally, although generally we're not telling you the ultimate outcome unless it is a matter of such clear legal certainty that we'll tell you, no, this you cannot do, but hopefully we'll tell you, but you could do it this other way. Or we will tell you there are two different options, option A, option B. Here are the risks of each option. Here are the legal risks of each option. And then it's up to you to decide whether those risks are appropriate to take for whatever policy reasons you deem appropriate. So it might be we're going to tell you there are two options. There's option A, option B. Option A is a little more risky. But you might think, oh, well, this is going to be more protective of consumers, so that's the position I'm going to take. And that's fine. And then if we get sued, we will be before the court, and we will tell the court adamantly that option A is perfectly fine. So that is our role as advocate versus our role as an advisor. And just to be clear, we provide you with a law, we don't provide you with policy. I told you how a number of deputies have years of experience in your field. And sometimes deputies will tell you, well, just to let you know, 10 years ago, the board had a similar issue. Here's what the board did. In doing so, we have to be careful as your attorney that we don't intrude into your space, that we don't become another board member. We are not there to be another board member. We're there to help you and to advise you. So when we're talking about issues, feel free to understand that and to ask us, well, are you telling us we have to do that as a legal question, or are you just giving us information about prior examples? Similarly, I would ask you not to ask us policy questions. So don't ask us, would it be better for the consumer if we did it this way? I mean, we might answer because we sort of like to be helpful. We like to answer questions, but it puts us in a difficult position because we can get accused, quite frankly, of being a board member and going beyond our role when all we were really trying to do is answer a question from a board member who asked us a question of perhaps a gray-shaded question, some of which was law, much of which was policy, and the answer sort of blurred that line. So we want to be helpful to you. We want to answer the questions. We generally will. But if you could also help us out by trying to ask your questions on legal issues, not policy questions, as well as not to be surprised if the deputy says, well, that's a policy question. It's up to you. I also wanted to let you know about contested case hearings and sunshine meetings. And I won't go through all the requirements. It is a very long and complicated process. It is an area that is very easy to get frustrated with. There are people there who do know. The deputy knows, your executive officer knows, but there are differences. And I just want to highlight just a couple of them for you, just to make you aware, because one of which is who can you talk to outside of a board meeting. Now, some people will just say, I'm not talking to anyone outside of a board meeting, and that's their right. They can do so. There's nothing wrong with that. But some people want to talk to people outside of a board meeting. And the answer to that is, if it's a sunshine meeting, you can talk to people. If you're going to try to consider what rule to pass, and you have other discussions with people about their opinions of the rules, and then it's going to come eventually to the board, that's okay. You may. It's up to you. There are policy issues as to whether you're talking to only one side or not, but that's a policy issue, not a legal one. And so that's your choice as to who you want to talk to and whether you want to talk to people about sunshine issues. Different from contested case hearings. Contested case hearings are more quasi-judicial. Those are the penalty hearings. Those are the disciplinary matters. In that, it's like a judge in a courtroom. The judge in the courtroom does not talk to one side outside of the courtroom. The judge does not go and talk to even a third party outside of the courtroom. The judge doesn't talk to his friends or her friends or the media. Well, I think this, or tell me what you think as to whether or not so-and-so is guilty. Judges do not do that, and neither can you. So when you have matters that come up that are contested case hearing matters, and say primarily the disciplinary cases, and licensing as well, I strongly advise you not to do that, or at least before you do that, check with your deputy or your executive officer to make sure it is or isn't something that's appropriate. That's the kind of thing that frankly, it's a purely procedural question that can get us into trouble. And if we get into trouble, I want to get into trouble on the merits. I want to argue with someone that we're right, you're wrong, you have a misunderstanding of the law, you have misunderstood the judgment of the board. I don't want to get into, if I can, or I want to avoid as much as possible those issues of, well, the process was wrong, notice wasn't given, an improper contact was made. Those are not the kinds of questions. Those are completely avoidable problems. So I'm happy to talk about it more, and I do want to leave time for questions for many of you, but I just want to leave that with you in mind. I said you can talk to anyone about what happens about a board meeting, but I do want to put one caveat to that, and there's one major exception, and that is executive sessions. So some of you may know about executive sessions. Normally board meetings are open to the public, but there are certain limited matters that can be held, discussed without the public in quote unquote executive session. And your deputy and your EO will go through some of the list of things that can be done in executive session. Some of the major ones are to discuss with your attorney the rights, liabilities, privileges, immunities, and liabilities of the board. Some of them include an evaluation of an employee, employer or officer of the state, and I believe DCCA has a separate one for the discussion of licensees. So those matters are discussed in executive session. That cannot be discussed by you to anyone outside the board meeting. I said you can talk about things in the sunshine meeting. That's an exception. So, and in part because the right or the privilege to release that information is the board's, not the individual board member. So, and I will tell you the biggest temptation is going to be where there is a disagreement. And you want to tell someone, this wasn't my fault. I thought this, so-and-so said this other thing, go blame so-and-so. You can't talk about that in executive session, about what happened in executive session. If you want to, you have to raise it to the board, and you have to ask them for permission. And generally it's not given, but you can ask. But those are the kinds of things that are tempting to do. Please avoid the temptation. Again, it creates problems that are just unnecessary and avoidable. I talked to you about malicious and improper purpose, and that you're good as long as you don't have a malicious or improper purpose, and so your house is safe. The one thing, you're going to have someone coming up here to talk to you about ethics. One of the aspects of ethics are conflicts. That is, are you using your state position for a personal or private purpose? Are you making a decision in which you have a conflict of interest? I just want you to know that you are always entitled to recuse yourself from a case if you believe there is a conflict. And I want to encourage you to talk to your deputy or your executive officer if you think there is a question. It's hard to go through the myriad and universe of possibilities in which that can occur. And I'm not saying every matter in which there is some tangential relationship to you is a conflict. It is not. That would be in this state. If we have someone in the industry and there's someone else in the industry, it's impossible to avoid. So I'm not saying every touching, or it's like, oh, I do know this person, I saw their name on an agenda. That's not a conflict. But there are various grades that will get you closer and closer in toward that. I only mention it now because it's again a completely avoidable mistake, and all I want to encourage you to do is to make sure you talk to the right people when you see that issue, and just to raise this as an issue in your mind. It will be, as you do this more and more often, it will become easier and easier to recognize. It sounds difficult sometimes because we describe it in general ways, because we have this universe of possibilities, we have this very, very broad definition. But as your particular examples work out, it will be easier and easier to recognize. And after, frankly, a couple of questions, you're probably going to figure it out. So for your particular example, it's not going to be that hard. I'm only asking you, in those first two examples where you're not sure, please ask. We are happy to answer. There's no such thing as a stupid question to us. There might be a stupid answer, but we'll do our best to avoid those. With that, I will make sure that I'm available for questions and comments. So, they asked me to speak for 30 minutes, and sort of my thought was, well, it's not hard to ask me to talk for 30 minutes. It's hard to get me to stop after 30 minutes. But I do want to stop here and just make sure I answer any questions you have. Somebody ask one question that will start.
Hi, Mike Jaffe on the medical board. So my question is, during this orientation, are we going to go over the mechanics of executive portion of the meeting? Because at our meetings, it kind of flip-flops in and out. I'm not really sure who's allowed to be there, kind of the mechanics involved, so I don't speak out of place. Yeah.
I'd be happy to answer the question. Should I just answer the question? Yeah. Okay. So let's go through the mechanics of an executive. That's an excellent question. It's going to occur. It starts with a motion in which you describe the reason for going into executive session. I move that the board go into executive session to, and then you institute, you insert the reason, to discuss with our Deputy Attorney General the board's rights, liabilities, privileges, immunities, and liabilities, can't remember the exact term. You get a second, you get a vote by the board, you go into executive session. Who should be there? Obviously, in this particular case, it's the attorney. It may involve those other state employees. It obviously involves the attorney and all members of the board. It may include other state employees, like your executive officer, perhaps the secretary, who are there and are necessary or appropriate for that particular discussion. It should not involve any member of the public. Unless that's encompassed within the executive session. Let me go through some examples. If you talk about so, and then let me distinguish from that the contested case hearing process. So the contested case hearing process, actually the public's allowed to be there as long as it doesn't violate some other privacy law. So it might seem like an executive session, but it's actually it's a different process, right? So one is a sunshine meeting, and you have an executive session to, let's say, evaluate a licensee's application, and that is then just the only people there should be the board, the attorney, and those DCCA employees who are appropriate for that discussion. Separate from that would be a contested case hearing in which someone has filed disagrees with a decision by the board, and there's a contested case hearing, and the hearing comes back before the board. If that's the case, then the meeting is generally public. But if, let's say, you're going to talk about something that's covered within a statutory exemption like mental health, alcoholism, then they can ask, I would like to close the contested case hearing to the public, and the board can absolutely and should do that. And at that point, then, it's allowed to be the board, the state employees, the attorney, and the parties to the case. Because you're not closed, because you have a contested case hearing, and you're closing it to the public, but not to the parties of the contested case hearing, because this is part of the contested case hearing. Then, separating from that is decision-making in a contested case hearing. So when you have a contested case hearing, let's suppose you closed it so that they could argue something about mental health or alcoholism. They finished that, and then you go into decision-making. Not because it's a sunshine meeting, but because it's a contested case hearing, you can have that decision-making process be done just with the board. Sort of like a three-member appellate panel on the Ninth Circuit Court of Appeals. I don't know if you were familiar with this. There are 3 judges on the Ninth Circuit for each panel. They don't have that discussion about what they should decide in public. The argument occurs in public, but their decision-making occurs in private. Your decision-making can occur in private as well. Does that see? I've given you multiple different ways to look at this because there are multiple different ways in which it occurs at a board meeting. You want to ask another question?
Who's in charge of calling the executive session? Chairman?
If you're in a sunshine meeting, it needs a motion by any board member, a second by any board member, and a vote. The chair will call the vote. And then, frankly, the practice, or what I have seen is most people don't object if someone wants to go into executive session. So then everyone votes, and it's almost always unanimous. But it doesn't have to be. You could have enough people. And then you would still need, okay, I'm going to go into the weeds. And I was thinking, let's not burden you with all of this information. But you need a majority of the votes to which the board is entitled. So you have 9 members on a board. You need 5 votes to go into executive session. If you have only 5 people who have showed up, you still need 5 votes to go into executive session. Any questions? Because I've been brilliant. Okay, well then, I think the only other thing then I wanted to make sure I let you know about is, oh, and I forgot to leave my card. I was going to put my card out in front. I will get that information out. But when you go to your how many people you've already been to your board meetings, right? Anyone not been to a board meeting yet? Okay, perfect. So you've been to your board meetings. You've met your deputy. If you need a card from the deputy, just ask. We have tons of them. We never use them. I've been 29 years. I don't think I've finished. So we're happy to give our card. We just really normally forget because unlike private, we're not trying to gin up any business. It's okay if we don't have more work. Yeah, no, we're available. You can call us. You don't have to wait for a board meeting. You certainly may raise issues before and after or during. The last thing I just wanted to tell you was the system can be complicated, and it is complicated. But there are a lot of people there to help uncomplicate it for you in any particular circumstance. So ask. Just make sure you ask. And if it seems unclear, because sometimes because it's so complicated, we don't explain it well. And I apologize now if I have not explained this well to you, but I know sometimes when we're discussing, the perfect example would have been the executive session question. It's a complicated response. There are multiple different processes, and there are different ways in which you go into a confidential discussion for each process. So if we are confusing to you, or if it's just a confusing topic and you need time to think about it, and then you thought, oh, I have another question, don't think to yourself, oh, I've already asked a question, I shouldn't ask again. Ask it again. Ask it multiple times. Ask it each time. Ask it multiple times, even if in the same discussion. It's perfectly okay. We welcome it. We actually like that dialogue. If you're happy being quiet and never asking questions, I'm not criticizing it, but I just want you to know we are available for anything, any issues you may have. If there are any other questions, after saying you should ask every other question, I see that has fallen on deaf ears. Nevertheless, thank you very much and welcome to state government.
My name is Bonita Chang. I'm one of the staff counsels at the Hawaii State Ethics Commission. And I was asked to do an overview of the ethics code, and I tailored it for boards and commission members. So some of the issues that you may encounter in your work as members of boards and commissions with DCCA, we'll try to cover some of the highlights of that points. But due to time constraints, I'm not sure that I'll be able to cover all the particular situations, but you can always feel free to contact us afterwards with your questions. Okay. So the State Ethics Commission is comprised of 5 members, and we have about 11 staff members at our commission. And our primary areas of responsibility include education, like trainings like today. We also provide guidance via phone is the main way that people call us, or email. We do more formal types of guidance as well. We also handle disclosures, including financial disclosures, gift disclosures, as well as lobbying disclosures. I won't be covering lobbying laws. That's a whole separate chapter, but we do handle lobbying disclosures. And then also we handle enforcement. Okay. The State Ethics Code is actually embodied in our state constitution under Article 14. So we're one of, I think we were one of the first states that actually enacted a provision as part of our constitution, and that's how important it was. And it's now codified under Chapter 84. So who does the State Ethics Code apply to? It applies to state legislators, state employees, and members of state boards and commissions like yourselves. It does not apply to state court judges because they are subject to their own code of judicial conduct. But state judiciary employees, like their staff members, they are considered state employees and therefore subject to the State Ethics Code. So today I'm going to just hit a couple of the topics that you would tend to encounter or possibly encounter. There are a couple areas that I won't be covering today, but the main areas that I'll cover today are financial disclosures, conflicts of interest, gifts, fair treatment law, and post-employment. I won't be covering confidentiality, since that's pretty much straightforward. Don't use or disclose confidential information that you obtain in the course of your work as board and commission members. And also contracts laws, which is very specific. So those are 2 areas that I won't be covering today, but I encourage you, if you have an opportunity in the future, we do provide more extensive training as part of our more regular standard courses, and there's one coming up in October, and then we also do it throughout the year. We're also going to be launching online training, so if you want to have more in-depth training, you can always attend those things. But today is going to just hit the highlights. Okay, so for financial disclosures, who must file? State elected officials, state board and commission members who are non-advisory commissions, and state employees in certain positions. And the main purpose is to identify potential financial interests that may conflict with your state duties. And I think for most of the DCCA board members, you're confidential filers. So it's all basically not publicly available. There are only 15 state boards that are public filers, which would be example like BLNR, Board of Regents, the larger boards. Okay, and then we launched about 2 years ago an e-filing system, and so I think the vast majority of people file electronically, and we're going to be doing further enhancements to the system. But if you ever have questions on how to file or you're unable to log into your account, you can always call our staff, and the staff members are always able to assist you and walk you through the process. Okay, so moving on to conflicts of interest. We're going to illustrate some of the provisions using these hypotheticals that I created. So looking at Carol. She's a member of the State Board of Examiners in Optometry, and the board is scheduled to hear a complaint against Volcano Eye Center. Carol's husband is an optometrist with Volcano Eye Center. Can Carol participate in this matter? Okay, how many of you say no? Okay, how many say, well, I don't think there's an issue? Okay, your gut instinct is correct. She has a conflict, and it falls under 8414A, which is also known as the disqualification rule. And this rule generally says, don't take official action directly affecting a business in which you have a financial interest. So in Carol's situation, it's her husband's employment interest that is affected. If she were to take an official action on her husband's employer, she may be tempted to go easy on them for fear of having him fired, right? So not to say that she would, but it just puts her into a split loyalty situation. And in other kind of situations, like say licensing, or where the husband's employer has a competitor, they could challenge that question and drag your board into a big mess. So for these situations, we always say she has a conflict and she has to recuse on that particular matter. Doesn't mean that she can't sit on the board, but just for that particular matter, she steps off the out of the meeting and doesn't take any official action. She best practice is to state on the minutes, I'm recusing myself for conflict. You don't have to go into like a full narrative, but just to state on the record, just so that it's documented, and then you can leave the room and then come back in when it's over. And then that way you have a paper trail in case anyone should challenge it. Okay, so when we look at financial interests, there are not just your employment types of interests, but ownership of a business, having outside employment, being a director or officer of a profit or nonprofit entity, like say a board member on a nonprofit organization that you volunteer with, owning property, debt, or you're a creditor, someone owes you money. So those are types of financial interests that are subject to the state ethics code. And in terms of whose financial interests we look at the employees, but we also consider the spouse as well as dependent children. Dependent children is defined as individuals that are claimed as dependents on your state or federal income tax form for tax purposes. So adult children would not be in that immediate circle. But as you'll see later on shortly in fair treatment law, it could come into play where there's an issue where if you're giving preferential treatment to an adult child, it could be construed as a fair treatment issue. Okay. And in terms of official action, what types of action you take, it's fairly broad. It's not just the decision-making itself, but it's also the review, the discussion, any type of discretionary authority that you take in your capacity as a board member. So that can be fairly broad. So let's look at John. Okay, John is a member of the Consumer Safety Board. The board has hired a consulting firm to develop a consumer survey on identity theft. The consulting firm is impressed by John's expertise on consumer safety issues and invites him to join the company's board of directors. Can John accept this position? How many says, yes, good opportunity, I don't want to give it up? How many says, no? Okay, you're correct. The conflict is he would be acquiring a new financial interest by joining that entity's board. And under 8414B, the general provision is don't acquire a new financial interest in a business if there is reason to believe you will be taking official action affecting that business. So in this case, he's already in an existing relationship with that entity, the consulting firm, and they're working with them on developing this consumer survey. So he's going to be working with them, and it could be, I don't know, contract extensions, approvals, change orders, who knows, right? And so that is already a vendor relationship. So he can't then join their board because then he's going to be conflicted out. And the notion is, the distinction that I always remember of the disqualification rule versus the new one. The disqualification rule is if you come into the state board with existing conflicts, then you recuse. But this one is don't go to the conflict, don't create new conflict, because we want you to serve for the public, and that's the first priority for the state, and don't go during your term creating new conflicts. Okay. Okay, so let's look at Shannon. She's a member of the Real Estate Licensing Board. She's also an attorney in private practice. The board has set a hearing on whether the license of a real estate broker should be revoked. The broker has asked Shannon to represent him at the hearing. If Shannon recuses herself as a board member, can she represent the broker? She's not wearing two hats. How many says no problem? How many says, oh, that looks weird? Okay. That actually is prohibited under 8414D, representational conflicts. So the concept of that provision is basically don't assist or represent others for pay before your own agency or on a matter in which you have participated or will participate. So in this situation for Shannon, it's before her own board. So even though she's like, oh, well, you know, pretend you don't see my hat as a board member, I'm just the attorney in this situation, you're still dealing with your colleagues, right? And so it's a little bit odd to then switch roles and go on to the other side of the table. So, and because it's, in this situation, her representation is presumably for pay, I guess, you know, there are situations where you're not doing it for pay, but that gets a little bit, you know, closer to the margins, and it could raise fair treatment concerns as opposed to an actual conflict. I would just generally say don't, you know, engage in that type of representation, whether for pay or not before your own board. It just gets too sticky, especially when you're dealing with a lot of your boards are licensing boards, right? You're regulating industries and other fields of area that affect consumers, right? So you want to be really staying, you know, on the right side. Okay, so as a sum up, conflicts of interest, which is really complicated, but if you remember anything, there's 3 general principles. Disqualify yourself if you have an existing conflict, don't create new conflicts, and don't represent or assist others before your own agency or on matters that you work on for pay. So those are just a quick overview of the conflicts, but conflicts is one of the probably more stickier areas. And so, you know, I encourage you, if you find yourself in a situation that you're not sure, you can always call us and we'll walk through the facts because it's very fact specific. Right. Okay. So moving on to gifts laws. Okay, gifts laws is under 8411, and generally the rule is don't accept or solicit any gift if it's reasonable to infer the gift is offered to influence or reward you for official action. So there are a broad range of gifts. So that would include food, gift cards, which are considered cash, concert shows or entertainment tickets, special event functions like golf, charity golf, and travel. So these are basically anything of value that you receive in your capacity as a board member. The factors that we usually apply to determine whether or not it's an improper gift would be, what is the relationship between you and the donor? That's one of the probably the more key factors. So if, let's say, it's a vendor relationship or it's a licensing or regulated entity situation, those are red flags. Or if you're a law enforcement situation, we usually say, you know, we would recommend declining the gift because of the special relationship. The appearance from an objective person standing on the side is it could be construed as an attempt, basically a bribe. And so the other factor that we do look at, though, is what's the value of the gift. Even though the gift law has no dollar threshold, we do take into consideration the dollar value relative to the other factors. So, and the third factor, which is also very important, is what is the state purpose? Is the gift essentially a personal gift to you, a personal benefit, and has no real state purpose? Or is there a high state purpose? Like, for example, something that helps you do your job effectively and benefits the state and outweighs the other potential factors that could be construed, okay? So it's kind of like a balancing test. When we weigh all those factors, that's why, like conflicts, gifts law is very fact-specific as well. So let's take a look at some hypotheticals to illustrate how that all plays out. So Laura, she's a PUC commissioner. She's invited to play in a charity golf tournament by an electric utility company that is regulated by the PUC. Okay. What's the relationship? Regulated entity, right? The value is most likely high, probably in a couple $100 range, including swag and whatnot, right? State purpose, and don't say networking, right? Because if it was a true networking situation, do it in a business meeting, right? Not on the golf course, right? There is, for the most part, a benefit to her personally. It's a social, function, right? It's also benefiting a charity organization, and she shouldn't, as a regulator, she shouldn't be in that situation of accepting that kind of gift, because it could be easily construed that it would be an attempt to influence her in a decision by the regulated entity. So this was an example that actually the commission had taken enforcement action about, 5 years ago. We had 40 golf cases that was actually published involving high-level government officials that were awarding state contracts in the millions of dollars to entities that were regularly inviting them to charity golf tournaments. And it was like a regular practice. And so the top-level officials, their names got published as part of the resolution of the matters, and they ended up paying like several $1,000s fines. The lower-level employees had differing values of fines, but basically they enforcement action was taken in that situation. So in this situation, we would say no. Okay, so let's look at another gift example. Okay. As the chair of the State Pharmacy Board, Kim is invited to speak at a conference in Seattle. The National Health Organization that is hosting the conference offers to pay Kim's travel expenses. Okay? How many says yeah? There's a state purpose. How many says, no, I don't know. She's getting a free ride. No one ever pays for my travel, by the way. This is a situation where the vast majority of travel requests that we get, this is the type of situation that we would say, oh yes, okay, no problem, because it helps to subsidize your trip, because otherwise your board or agency would send you anyway, because plenty state employees have to represent the state, going to these national conferences. It helps them do their work. They might be some sort of conference sponsor or think tank or foundation, doesn't generally do business with the state. They want to encourage government officials to attend, so they will have a small pot of money available to help subsidize your travel. So those usually situations where the gift value may be very high because it's mainland travel, but the state purpose is so high that it outweighs any, the relationship is so minimal, that there's no concerns there, that the state purpose would outweigh the other two factors, right? The other kind of examples that we encounter that's not even a gift would be if the state agency is a member state of that entity. So sometimes like the AG is a member state and they have to send a representative to that meeting on a national basis. Their dues, Hawaii pays dues that covers that membership, and it includes travel. Those aren't even gifts. It's part and parcel of your membership. So those are completely different. But if you're not sure, we do have travel questionnaire forms on our website. You can fill it out and then call us up, and then we can walk through the analysis. And the vast majority, like I wouldn't say 99% of the travel requests that we get are all okay to accept, just report the gift. Okay. So to sum up the gift analysis, the first question is always, can you accept the gift? And then the second question is then, are you required to report it? So for the gift disclosures laws, which is separate provision under 8411.5, you have to report if the value of the gift is more than $200 and the donor has interest that may be affected by your official action. So generally we say if it hits the over 200 level, then just report it. And the gifts reports are usually due June 30th. And we have electronic filing for that, and you can fill out the form online. Okay, any questions on gifts so far? Question.
In the previous example, when the officials took the golfing invitations, so is that a situation where the liability is not protected?
Yeah, just because you report doesn't mean that you're insulated. Yeah. So generally, the office will review gift disclosures and kind of preview, say, are there any issues? It might prompt a routine follow-up question because maybe there's something there that's we didn't know about because it's just a form, right? So we'll probe a little bit more and ask for clarifying answers. But generally, if we recommend you call us before accepting if you're not too sure. Because there always is a what we call an attorney of the day. So we handle the hotline basically, and we rotate it. So each person every day is covering the phones, and we'll handle the questions. So generally, we try our best to get to your question right away. Unless it's a super busy day, then we'll call you the next day. So we try to respond, or via email. If you have a quick question, you can send it out, and then it gets assigned to the attorney of the day. Okay. Any other questions on gifts? Oh, okay, sorry. Let me repeat the question. So it was a question about financial disclosures, and if you acquire an interest after you submit your disclosure, do you need to file an updated disclosure, right? Generally, we don't expect you to constantly be updating your disclosures form. You can, because the electronic system now, it's easy because you can amend and it will grab your your last filed information, and you can update it very easily. But generally for our office, for administration purposes, it's pretty much the once a year cycle. And then we catch you the next time around, right? The only time I would say call us if you're about to acquire something is if it creates a conflict where I say, oh, you know what, you shouldn't acquire that that interest. It might create issues or whatever, or more for guidance purposes as opposed for the disclosure, because people's lives throughout the year, you might have a lot of changes, and so we can't expect you to constantly be updating the form. Like it's almost like I don't want to equate it to tax forms, but it's kind of like if you think cyclically. Once you file your initial disclosure, then it's the May cycle for board members. Legislators are January, but usually I don't, like legislators, I don't expect them to file like every month when something, changes or whatever. Because you could have like, say, stock holdings or you sell property. It's just too much, right, to constantly change. So generally.
So I just, so that was just a yes or no question.
Yeah, so no, you don't have to update your form.
And then the only reason why is, in another life, right, because we're volunteers, I don't want to make work harder, make more work, but on the state end, in another entity, we do annually report disclosure, but if anything changes, we're supposed to report within a very short period of time. This is the university.
Right.
So I was just wondering, because usually state entities tend to be, despite the perception, tend to be fairly consistent with procurement and all the other things. So I just wanted to make sure that this was not the Ethics Commission's requirement. Just to be sure, because that's one less thing I have to think about.
Yeah. So we just send you that notice, for that May filing, and you just add an update from the year before. All that
and this
changes.
May be a little bit different, but I think in the context of speaking engagements, like say by this national organization, how would you want us to approach disclosures at that entity? Because, for example, even if, say, we're chair of a board, we're limited in the scope of what we can say on behalf of the board. And so can you touch on that just a little? It's a little bit different from what you're talking about, but it does deal with managing conflicts of interest.
Okay, I don't know if it's so much a conflict, but more of a fair treatment in terms of you don't want to be misusing your position, or using your position as a state board member in some other private capacity. So, or dragging your board into a matter that's not their official role. I guess it would be more of a fair treatment question.
So I think, so what you're talking about is real easy. We just put on the disclosure slide, right? That it's, we can just put on a disclosure slide that it's our opinions and not that of the entities with the privilege to serve.
Right.
But the example that's in the packet, like when you're invited by a national organization,
right,
and the context is that you are chair of your board,
right,
and you're being invited based on that premise,
right,
then the question I have is if you can clarify what is the scope of what you could say in that particular setting when you're invited by another organization,
right,
because of your role as a board chair or member. What can you say on behalf of that entity? How should that be managed in terms of potential conflicts there?
Right. So if you're invited in your state capacity, right, either as a speaker or as an attendee, you're going on state time. So you're representing the board in that capacity. So you're, you know, the reason why you're there is because you're a state official wearing that hat that moment, as opposed to just, you know, paying for your own pocket and going to some private function or conference and it relates more to your side employment as opposed to your board role. Those are kind of like separated, right? It's always good to kind of, if you're a, you know, I guess, well-known board member, it's always good to have that qualifying language just to kind of preface it. But if you're invited in that gift scenario for the travel, I would recommend that you check off with your agency or board, you know, in terms of taking any official position, because usually going to those conferences because you're representing the state board on some, I don't know, it could be national rules, codes, whatever, right? So you want to make sure you're representing the state's position and not deviating from that. As additional reminder, when you go to those kind of things and you're inviting your state capacity, you should not accept honorarium. You can donate it to your agent because you're going on state time, right? So the honorarium would be considered, I'll cover it in the fair treatment section, but it's considered additional compensation because you're already going. So you would then, more so for state employees, they often get that, right? They're paid like a director of whatever. They'll go to the board to speak on some matter, and they're given an honorarium. They can donate the honorarium to their agency because it's basically compensation to the state. They just can't pocket it because otherwise that's like getting extra money, right, for going in your state capacity. Like I can't go to an ethics conference and get paid, you know, extra for that. Okay, so I hope I addressed some of the issues, but again, if you have more specific questions, you can always call us after today's event. Okay, so I'm going to move on to fair treatment. So fair treatment, I touched on it, you know, real briefly, but basically the general concept is fair treatment, being fair, not giving preferential treatment to benefit yourself or others. So the general rule is don't use your board position to benefit yourself or others. Don't use your position to do favors for friends or family, and don't abuse your authority. And in, you know, the headline news, we've been hearing a lot of abuse of power, you know, misuse of position, misuse of state resources. This is under fair treatment law, and it's generally under 8413, but there are specific provisions under the fair treatment law. Fair treatment law would also include using your state position to seek private work or contracts, right? So, hey, you know, what kind of opportunities do you have? And you're negotiating as part with a vendor or someone that does business with your board to then parlay that into your private opportunities for yourselves. Additional double compensation, as I touched on, and then also financial transactions with subordinates, more so for supervisors in employee side, but basically, you know, don't engage in substantial financial transactions like, say, selling your car or buying loans or whatever because of the imbalance of power. Also, another area of fair treatment is using or misusing state resources for private business purposes. So that would include profit or nonprofit entities. So that would be like fundraising, campaigning on state time, running businesses. We've seen the whole gamut of private business activities. And state resources would include state offices and facilities, state time and personnel, office equipment, state email system, and even, you'd be surprised with state equipment, like heavy equipment. So those are kind of like a quick overview of the fair treatment law. Any other questions on fair treatment? Okay. So the next area, the last area is post-employment. So this would be after you leave the board and your term is over, there is generally post-employment provisions and restrictions. It's under 8418, and the general concept is to prevent you from engaging in influence peddling or the revolving door effect of leaving state and going to private and using the influence that you have in the state board to benefit your post-board role. There's a 12-month cooling off period. So from the time you leave the board, let's say your term ends June 30th, then July 1st till the July 1st of the following year would be the 12-month cooling off period. And during that 12-month period, you cannot be paid to represent another person or business on matters before your board or agency, or matters in which you participated while sitting on your board. So that's basically, a 12-month period to just cool off, and then after the 12-month is run, you would then be free to appear before your board on whatever matters. Of course, the confidentiality rule, there's a confidentiality provision under the post-employment law, and that's forever. There's no 12-month period. If you obtain confidential information during the course and scope of your work as a board member, you cannot use and disclose that ever. So just because the 12-month is up, you can't be revealing that kind of information, because that is confidential. And confidential means information that is privileged by law, or information that is not publicly disclosed. And it's not necessarily like procedures, but more like deliberation, internal decision-making, the reasonings, things that you would not disclose subject to a FOIA or a UIPA request. Okay. There are also a number of exceptions for post-employment. The board could always bring you back and let's say hire you as a consultant to help them for state purposes, or usually, like say, we've seen it more on the employment side, where the employee is brought back on an 89-day hire to finish up their work, to train the successor. Those are usually the post-employment exceptions. Board members, I don't know what scenario that might come into play, but again, if you have post-employment questions and you're not sure, feel free to call us. Any questions on post-employment? Okay, so quickly going over penalties. The fines are up to $1,000 per violation. If we go through a full hearing and we find that you violated the ethics code, we would then refer that matter to your employing agency through the governor for further disciplinary action, whether it be, I don't know how it plays out in the board situation, but that would be within the purview of your agency. Recovery of gifts or profits would be handled by the Attorney General, and contracts or actions can be voidable. As I mentioned, if you remember anything, it's that you can always ask us for questions and for guidance via telephone, email, staff letters, or we can provide guidance in the form of either verbally, through emails, a little more formal staff letters if you have more of a complicated situation, and in the more formal situation would be the advisory opinion. Usually those are reserved for questions of unusual ethics situation that the commission hasn't encountered before, or situations where you just really want the advisory opinion. We have issued several, just even this last couple months, dealing with situations that were fairly unusual, that the individual wanted a formal advisory opinion. It's a little bit, goes through a different cycle, and there's a timing period to that, but that is an option available to you. But the vast majority of questions that we get are phone or email. So feel free to always call us, and advice is confidential. Okay, and then lastly, the contact information is available in your handout, so feel free to contact us. And if you have any questions, I think we're gonna, I don't know if you're gonna have a break or not, but You can always call our office later today or next week at any time. Thank you very much.
Good morning. I am Jennifer Brooks. I am a staff attorney at the State Office of Information Practices. And I'm going to give you a quick introduction to our office and the laws that we administer. So we administer both the state's open records law, the Uniform Information Practices Act, and the state's open meetings law, the Sunshine Law. And for both of those laws, we give advice. We do take complaints, take appeals in, and do opinions on disputes. We do training. This includes a lot of training that we have online. And, I should note this isn't a training. We don't have enough time to do a training. This is really a very brief introduction, but we do have our guide to the Sunshine Law and guide to the UIPA included in the packet that you got. And we have full trainings that are online, including streaming, voice-over PowerPoint slideshows that you can watch if you want to get a full training on either or both of those laws. And then we also, during the legislative session, we do a lot of commenting on bills and so on that are related to our laws. We also assist in the state's open data initiative. And we have what we call our Attorney of the Day service. Every workday, we have one of our staff attorneys assigned as that day's Attorney of the Day, so that when you drop by, call in, send us an email, we have somebody who's available to answer general questions. And that's usually, usually if you call, usually somebody can take it right then, but if not, you'll get an answer within the day. So I will briefly touch on the UIPA, and then I'll spend a little more time talking about some of the basic elements of the Sunshine Law. But, again, as I say, this is an introduction rather than a training. So the Uniform Information Practices Act applies to government records, and so you should just be aware as board members that the records of your board's work are generally going to be government records, and as board members, there can be sort of fine points as far as things that are written from your personal email account. Is that really accessible to the government agency and so forth? But just be aware that particularly the records that are maintained by the agency that are relating to your board's work, these are government records, and as such, it is possible for members of the public to request them. Now, if you get a request for records in, it's probably not going to be coming to you as board members. It's probably going to be going to agency staff, the administrative staff that supports your agency. But when a record request comes in, a written request, the agency has to respond to within 10 business days. So that's 2 weeks typically, usually by doing a notice telling the requester what we're giving, what we're not giving, whether we're withholding it, whether there will be fees. And another thing for you to realize under this law is that records are presumed public. The presumption is that it's public. There are exceptions that may apply, but it's up to the agency to say why the requester should not get the record, rather than being up to the requester to explain why they should get the record. So, like I said, a very brief introduction to the UIPA, just so that you know it exists and that people can request records related to your work. I'm going to spend most of my time doing a quick run through of the Sunshine Law, some of the basic concepts under the Sunshine Law, since that's the one that's going to be more applicable to what you folks do as board members. So the Sunshine Law is Part 1 of Chapter 92 in the Hawaii Revised Statutes. It applies to, it's the open meetings law. It applies to meetings of government boards, boards being a defined term under the Sunshine Law. For you folks, you can just assume that you are board members. And it applies when board members are talking about board business. So that would be anytime you're talking about specific issues that either are pending before your board or are reasonably likely to come before your board in the foreseeable future. So something on an upcoming agenda, something that isn't on an agenda yet, but is likely to be coming your way. Whenever you're talking to another board member about that, that's a discussion of board business, and so one way or another, the Sunshine Law applies. So to start with some of the concepts that arise before a board meeting, a board needs to file a notice and agenda before holding a meeting, and there's also a concept called board packet that's fairly new in the law, which I'll also touch on briefly. So the notice and agenda, that has a deadline for being filed. It has to be filed 6 days ahead. That's calendar days, not working days. 6 days ahead of the meeting on the state or county calendar, also with a copy to the lieutenant governor, or, well, in your case, you're all state boards, so state calendar, copy to the lieutenant governor, and keep proof of filing, and it goes out to people on the mailing list. Now that notice, in addition to time, date, and place, has to include an agenda that lists all the items that your board will be considering, with a limited ability to add minor stuff at the meeting by a supermajority vote. So the level of detail that the agenda has to have it has to be sufficient to inform the public well enough so that people in the public can consider whether they want to attend the meeting and testify on the items you're going to be considering, for which reason that you can't do things like having just old business, new business without further detail, because of course nobody knows what you're going to be talking about. You can't have catch-alls, things like applications, if any, because again, it's not enough for people to know if they're interested and they want to come and testify. And this is something where we have quick reviews and agenda guidance online if you want more information on the level of detail that would be required for specific items. But as board members, just be aware that, first of all, something that's not covered on your agenda, you can't start talking about at the meeting, and you can't allow for that. You can't get around that by saying, well, we'll just have a catch-all of, other applications, if any, or something like that. And then the other thing is to realize that even if it's your staff that's preparing the agenda, they need to be knowing a week or more ahead of the meeting what is going to be considered so that they can get that agenda prepared and meet the filing requirement at least 6 calendar days ahead. The other thing that comes up before a meeting is this board packet requirement. And this is something that applies only if you actually have a board packet. A board packet would be material that is pulled together and sent out to board members in advance of a meeting for their consideration before a meeting. So if you don't have anything like that, then actually there's no requirement to have a board packet. But if you do have something like that, and I think in many cases, many of your boards will have something like that, that might be pulling together copies of applications that you're reviewing or similar things. The requirement is that as soon as it goes out to the board, there has to be a public version of it available in the board's office with a notice sent out to the mailing list stating that it's available as well. Now, that doesn't mean if what you're reviewing includes confidential material, it doesn't mean that, well, too bad, it's all public, because the way the law is written, it does allow for withholding not only things that would not be public under the records law, the Uniform Information Practices Act, but also allows for, because of the quick turnaround, because this has to go out to the public at the same time as the board, it also allows for situations where if it's just too time-consuming to redact, you can withhold the whole thing. But generally, your staff is going to be wanting to, as things come in, they're going to be needing to prepare a public version so that that can go out at the same time that it goes out to you folks. So when you get if you're getting a board packet, you know, when you get your board packet, be aware that there's going to be a public version of that people may be seeing, and if you get questions from constituents, you can point them that way. And also be aware that, you know, if it should happen that you have something that you're suggesting, you know, there's this federal government report that's relevant to the work that we do, and can that get sent out to the other board members? You know, that probably can, but it will be part of the board packet, and so it will be subject to the same requirement. And for staff, by the way, well, I know PVL staff has already been trained on this, but just note that you're not required to automatically mail out this whole packet. The requirement is to have it available and accommodate requests to send it out electronically as soon as practicable. So let's move on to the during the meeting stage, some concepts that are important during a meeting. First of all, testimony. The public has the right to testify on any agenda item, and agenda items means there's not a right under the Sunshine Law to have a general public comment period. Some boards like to do that. Depending on the mission of the board, it may be appropriate for them to have a general public comment session, but just be aware that that's something that while you can choose to do that as a board, you're not required to. The requirement is to accept public testimony on items that are actually on your agenda. Now, testimony doesn't include a right to question the board, which again, is something you can answer questions if you want to, but you're not required to. I know some people, when they come in to testify, like to do it in questioning terms. How can you explain da-da-da-da-da? Why did the board da-da-da-da-da? Again, you're not required to answer questions as part of receiving public testimony. Testimony can be oral, it can be written, it can be both. Written testimony, you know, typically an agenda is going to give people some information on where they can submit written testimony. If somebody submits testimony to you as a board member directly, just pass it on to the administrative staff so that they can ensure that it gets appropriately copied and distributed to other members. People can testify anonymously, more challenging in person, but you know, either way, that means that while you can have a sign-in sheet and request that people sign in, you can't actually require people to sign in as a condition of testifying at a meeting. And people can testify on the same agenda, or the same agenda item each time it turns up on an agenda. You know, sometimes you have these issues where it's just meeting after meeting, it's on there for every meeting for 6 months running or something like that. And sometimes you'll get people who come and they give the exact same testimony every time, which you're just going to listen to it again because, you know, again, the way the law is written, every person can testify on every agenda item at every meeting. Now, as a board, you can only discuss or act on items that are on the agenda, and while you have, as I mentioned earlier, an ability to add minor items by 2/3 vote of all members to which the board is entitled, which, by the way, means you have to have pretty good attendance if you're going to even do this, you know, for the most part, just don't expect to be discussing things that are not on the agenda already, which means that if you get off-topic public comments, either in the course of their testimony on an agenda item, or if you have a general public comment section and they're talking about something not on the agenda, be aware that you can't, just because somebody raises it in testimony doesn't mean you can then discuss it. So you're going to have to typically have the chair say something like, thank you for your comments. We can't, it's not on our agenda at this time, but we'll consider it for a future agenda, or, you know, that's going to be on our agenda for our meeting next month, or something like that. Now, the other thing that comes up during the course of a meeting is executive sessions. That's the Sunshine Law term for a closed meeting or closed portion of the meeting. If you anticipate having an executive session, like there's something where you expect you're going to need to talk to your deputy AG during the meeting with legal questions, or there's something where if you were in the position of discussing personnel, hire, fire, discipline, evaluation, discipline dismissal of personnel where an individual's privacy would be concerned, that's another one where you might anticipate you're going to be going into executive session. If it's foreseeable, put on the agenda, when you list the agenda item that you'll be discussing, also note that you anticipate going into executive session. If it wasn't foreseeable, if it came up and you realize at the meeting, say, oh, we have a legal question, we need to ask our attorney, you can still go into executive session. So it's not an absolute requirement that it be on the agenda, but if it's foreseeable, it should be. What you need to do at the meeting is to announce the purpose of the executive session. There's a limited list of 8 purposes, so you can't just say, we need to go into executive session. You have to say why, and the why has to be one of those 8 listed purposes in the Sunshine Law. And again, we have that Attorney of the Day service, so if there are questions ahead of time where you think you might need to go into executive session, but you're not sure you're able to, you can always call the Attorney of the Day. But, you know, let's say you have a legit purpose, so you announce the purpose, you vote by 2/3 majority of those present to go into executive session, and then once you're in executive session, you know, it's not a license to talk about whatever you didn't want to talk about openly. You're limited to discussing those topics that are actually on your agenda, of course, and that can't be discussed openly without frustrating the purpose for which you went into the executive session. So let's move on to concepts that come up after the meeting, and this is primarily the minutes. A board's minutes have to be online within 40 days of the meeting. The board has the choice to keep its minutes in either written format or recorded format with a written summary. And for those of you who've been sitting on boards for a while, you may be thinking, recorded format? What's that? That's relatively new, but it is something that was added to the law a couple years ago and now is an option. So written minutes are the way they always have been. Written minutes include the time, date, and place. They include who's there, who's absent, the vote for or against any motions by member. And by the way, unanimous votes work because the minutes already show who's there. So if the vote was unanimous, then you already know by member everybody who was there voted in favor. So you don't have to specifically list each name if it was unanimous. But if it was, say, a 5-to-1 vote, vote by member does need to be reflected, so you would list names. The minutes need to reflect the substance of all matters discussed and the views of the participants, which means that written minutes should reflect who spoke and the gist of what was said. It doesn't have to be verbatim, but if a particular member spoke, you should be able to tell from the minutes that that member spoke and at least the gist of what they said, the general direction of their remarks. So you don't want to have in minutes things like discussion was had. Minutes are also required to include anything a member requests be included, and we interpret that to be anything a member requests at the meeting be included, because otherwise it doesn't work with the deadline to get them online and the requirement of accuracy in minutes if members can then have an absolute right to request additions or changes much later. So as a member, if you want something included in the minutes, you can insist on that, but do so at the meeting. Please let the minutes reflect that, something like that. For recorded format minutes, they need to include the recording itself, digital recording or analog recording, but as a practical matter, the board is generally going to want to take a digital recording because the minutes have to go online, as mentioned earlier. So the recording, a written summary. The written summary has to include time, date, and place, who's present and absent, vote for or against any motion by member. So far, you know, this is all stuff that's also in the regular written minutes. The difference is that where the written minutes have to have the substance of all members discussed and views of the participants, i.e. either that transcript or the paraphrase of what all the discussion was. The written summary accompanying recorded format minutes only needs to have a timestamp or similar reference for when the board began discussion of every agenda item and of every motion or vote. So kind of a table of contents for people, whether it's board members, staff, or members of the public trying to see what happened at a meeting. They can, because recordings can be long and it can be very tedious to try and forward through to see when discussion starts. So this lets people know, agenda item 10A discussion began at 11:37, something like that. Now, written or recorded, all minutes have to be a true reflection of what happened. In other words, the law does actually require that they be accurate. Executive sessions, you're required to keep minutes. The minutes are not automatically public. You're not required to post your executive session minutes 40 days after the meeting like you are with the regular session minutes. But again, you do have to have them, and if someone requests the executive session minutes, the standard is that you can withhold insofar as disclosure would frustrate the purpose of the executive session. So immediately after the meeting, if you were properly in executive session and someone requests the minutes, for the most part, you're not going to be disclosing. Some years later, it's possible it would no longer frustrate the purpose. One of the executive session purposes is where a board is considering purchase of public land, for instance, and if it's 5 years later and the purchase has either happened or hasn't, it's likely you're not giving away much by revealing that. Others, though, like the personal privacy one, that might keep it indefinitely. So again, executive session minutes, be aware that you do have to keep, as a board, executive session minutes, but also be aware that they're not automatically public. Okay, final element I'm going to touch on is things that happen outside of a meeting, and by this I mean the permitted interactions. The Sunshine Law, I mentioned all the way up front that anytime you have board members discussing board business, the Sunshine Law is concerned. The Sunshine Law applies. If it's in a meeting, then obviously it's, all those standards we've talked about previously. If it is outside a meeting, then to be legal, it needs to fall within one of the permitted interactions listed in the Sunshine Law. So there is a special section in the Sunshine Law, this is 92.2.5 for anyone who's wondering, that sets out circumstances in which board members can talk about board business outside a meeting, and it is specifically permitted by the law. So I'll mention, first of all, the investigative groups or permitted interaction groups, or PIGs as they're sometimes called, because that's a frequently used one. This is the one that allows a board to name members, less than a quorum, specific members named at a meeting, and set their authority at a meeting, and then allows those named members who are now part of this permitted interaction group to go out, and they can freely amongst themselves or with other people who are not members of the board, they can freely discuss the topic assigned to them outside of a meeting without having to go through the whole open it to the public, keep minutes, and so forth. So when you set up one of these, sometimes they get used in situations where it's not that the board is trying to do anything secretly. Maybe it's something where they actually want to go out and talk to members of the community, but it's, for practical reasons, awkward to do it as a Sunshine Law meeting. But it can also cover situations where it's something that the board does want to do without trying to involve the community, either because it's something that's like, writing a response to something that came in from a federal agency, or writing a response to some other correspondence where it's kind of awkward to draft anything during an open meeting or a meeting generally. But it can also be things where, yeah, you are actively trying to do something where you're handling sensitive information that maybe doesn't fall under one of the executive session purposes, and so you want to have this less than a quorum, this small group of board members deal with it and then report back in a more sanitized way. Again, there can be various things that you're trying to do with it, but regardless, you have it so that the members of this small group now can discuss it outside of a meeting, but they can't involve the other board members who are not part of this permitted interaction group. They have to make sure not to cross the streams. Now, the permitted interaction group members report back to the full board at a subsequent meeting, and the expectation is that, you know, the first meeting the group was created, they go off, they do their thing, they come back, they report to the full board, and now basically they've dissolved. They're not continuing to meet. The full board then has to wait until the next meeting after that to discuss and take action on whatever the topic was. Our understanding of the reason the statute is set up this way is because otherwise the public wouldn't have any chance to weigh in before the board considered and possibly took action on it. This way the public gets to hear the permitted interaction group's report and can then testify on it at that next meeting before the board considers and takes action. So again, that's one that's frequently used. Other permitted interactions, well, there's the one that allows two board members to talk about board business to each other so long as they don't make or seek a commitment to vote. With this one especially, although it's true for all of them, be aware that you can't use it serially. You can't have A talk to B and then B talks to C, because now you have A, B, and C all privy to the conversation, even if they were never in the same room at the same time. Another frequently used one is there's one that allows less than a quorum of board members to attend an informational meeting as long as it wasn't set up specifically for the board and as long as, again, they don't make or seek a commitment to vote. So this means that, you know, there's a relevant legislative hearing, let's say, and you have a 9-member board, and there's 4 of you that show up to testify on this same bill. Well, you're okay because you're covered by this permitted interaction. However, you do need to report your attendance at the next board meeting. So that would be something like, you know, I went to the legislative hearing on SB 1234, and members A, B, and C were also there. You know, there was a lot of public concern about this bill, on this issue and that issue. It was very educational. It was something like that. Not a written report, in other words, nothing very formal. You're just letting the people who attend the meeting know that, hey, there were several of us board members at this event, and this is briefly what happened. Less than a quorum of board members can discuss leadership. The full board can discuss minor administrative matters with the department head. The full board can discuss anything with the governor, but it does actually have to be the governor, not the governor's chief of staff. And there's a couple of others that are not as often used. Again, OIP's role with this law is we offer advice both through our attorney of the day advice and sometimes advisory opinions. We take complaints and issue determinations on complaints, and we do training. And we are always happy to hear from you. If you have questions, you can call the AOD. I don't think we have a break now, so I can't take questions right now, but you know, if you have questions later, you are welcome to either email me directly in this case or not forever. Don't email me forever. But if you have questions today, you can contact me or just contact our office and ask for the attorney of the day. Thank you. My name is Esther Brown, and I am the Complaints and Enforcement Officer for the Regulated Industries Complaints Office. This morning, I'd like to provide you with a little bit of information, brief information about what it is that RICO does. I'd also like to provide for you some information about how you, as a board member, will be interacting with RICO in your capacity as a board member. Okay, so first and foremost, RICO is a statewide agency. So we are a division of the Department of Commerce and Consumer Affairs, and we have offices throughout the state. Our largest office is here on Oahu. We also have 2 offices on the Big Island. We have an office in Maui, and we also have an office in Kauai. RICO is the enforcement entity for the professional and vocational licensing laws. So we work really closely with PVL, and we'll be working really closely with you when it comes to matters affecting licensees. RICO is organized into 3 major sections: the Consumer Resource Center, our Field Investigations Unit, and our Legal Section. Okay, and let me tell you a little bit about each of the sections. The Consumer Resource Center is our front line. We are a complaint-driven entity, meaning we act on complaints of misconduct by, in your situation, your licensee. So we are complaint-driven. Consumer Resource Center is our front line. Using a criminal analogy, the Consumer Resource Center is like the police. They get the 911 calls. Something is happening. Can you look into us? Okay. So they intake inquiries. They answer questions from the public, from licensees, from respondents, officials, etc. They receive and refer complaints for further investigation. And anyone can file a complaint with our office. You can file a complaint, a member of the public can file a complaint. We get complaints from businesses, from competitors, hospitals, employers, etc. So anyone can file a complaint with our office. The Consumer Resource Center is primarily charged with reviewing the complaint to see whether or not there's something that we can do with that complaint under the licensing laws. So they are the front line for RICO. Our second unit is our Field Investigations Unit, and they're the meats and potatoes of RICO. They are comprised of experienced personnel who investigate complaints to determine whether there is a possible licensing law violation. So these are our investigators. They are the ones that go out into the field. They would talk to the licensee. They would communicate with the person who is complaining. They would determine what sort of information or evidence that we would need in order to make an evaluation of whether or not there's a likely licensing law violation. We have several, I just love my field investigative staff. They are just awesome. We have several members who have a lengthy history of law enforcement investigation, and many of them have a long history in regulatory investigation, so they know how to do their work. The final unit in RICO is the legal unit, and this is the one that most of you will be interacting with in your capacity as board members. The legal section is comprised of attorneys, and they actually prosecute complaints that involve potential licensing law violations. Just to give you an idea of sort of the work that comes through RICO every single year, for fiscal year 2018, we had approximately 2,800 complaints that were processed. 2,800. So if we were to divide that number by the amount of full-time investigators in our office, as well as the amount of full-time attorneys that we have, that would average about 190 complaints investigated per full-time investigator, and 358 complaints handled per attorney. The work that we have at RICO, and the biggest challenge that we have at RICO, is the workload issue. If any of you were to come down to my office, you will see in the offices stacks, piles of cases and evidence and information that is gathered. That is the environment in which we operate. It can be daunting at times, but nevertheless, RICO has a great staff. They're very committed. They work long hours, and they try their best to get to all of the complaints that have been filed. And the 2,800 complaints that we received and processed in fiscal year 2018 doesn't account for the pre-existing complaints that were already in inventory. So the work is daunting, but we have a great staff, and they are very committed, and they know what they do. In enforcing the licensing laws, we have several tools, so I'd like to talk a little bit about that with you as well. The enforcement tools are, we regulate unlicensed activity, number one. We have a pretty good education campaign in order to reach the public, and we also, the final part of it, which is what the meats and potatoes of what we do as an office, is complaints processing and prosecution. So let me talk about the regulation of unlicensed activity. This is probably one of our most effective enforcement tools because all of you sitting here went through the process. You got educated, you paid to go through some program. You got the training and expertise needed to do what it is that you do on a daily basis. You got your certificate or your permit or your license, and you're out there practicing with members of the public. Unlicensed people have done none of those things, and they're out there and they're taking your work and they're exposing the public to risk. So we enforce the licensing laws by enforcing against unlicensed persons. You won't see cases or complaints involving unlicensed persons because as a member of the board or commission, you do not have jurisdiction over them. Those matters are handled through the circuit court process. Those matters will often result in monetary fines or injunctive relief, which basically means they get fined for engaging in activity that requires a license, and number two, they are prohibited by the court from continuing to do so. And I will be quite honest with you that there are some challenges in regulating unlicensed activity. One of the main challenges is that there's just a high recidivism rate among individuals. There are just people out there in every single community that fly under the radar and choose to do illegal conduct, and they are repeat people. So they're just out there. The other challenge is that there are homeowners or people that are willing to engage unlicensed people because the costs are costs, et cetera. They can do it quickly, on and on and on. So there are people in the community, a lot of them, that freely use unlicensed persons to do the work. The other challenge that we face is that this is Hawaii, people. We are an Ohana community. You guys probably know somebody that knows me, and I probably know somebody that knows you. We live in a community where we care about one another, and as a result of that, we just don't want to get involved. We don't want to rat out people. You know, we don't want to do X, Y, and Z. So because unlicensed activity matters are prosecuted in our courts, we have to meet an evidentiary burden. And a lot of times, we have people that are willing to report it. Hey, so-and-so is down the street, you know, and they're working on this house and they don't have a license. Go check them out. So our investigators go and check them out. But when it comes to, hey, we need more information, what did you see? Because by the time we arrived on the scene, they were gone. So what did you see? Why do you think they were unlicensed, et cetera? It's very difficult to get evidence. And if a homeowner is willingly using an unlicensed person, they're not going to cooperate. So those are some of the challenges with going after unlicensed activity. Nevertheless, RICO has this awesome unlicensed task force so that whenever someone calls us or stops by or tells us that they think there is unlicensed activity going on, the task force is on it. They're out there as soon as possible. And again, much of the time, the activity is ceased by the time members of the task force arrive on scene. But they have been very successful in other areas. Contracting is very, very difficult, but in other areas, they have been very successful in getting out into the community and catching people in the act and issuing citations. So the main way that we regulate the professions for you to ensure that the proper people are doing the work that you have invested in is through the regulation of unlicensed activity. The second enforcement tool that we have is education. RICO, as you know, and the professional and vocational licensing boards consist of 51 broad licensing areas. Okay, that's over 4,000 statutes and rules that we are responsible for enforcing. And I will admit, there are some that I haven't even looked at in my 15 years with RICO, honestly. There are. But nevertheless, it is a daunting task. And so we believe at RICO that knowledge and education is an is a critical tool for enforcing in the area, and so we do expend our resources in the area of education. First and foremost is the Consumer Resource Center. Again, our frontline. People that work in that section are incredible. They just have a way of dealing with the public. They are just so good at listening, sometimes for hours, to people just complain and complain and complain, and they try to narrow the issue down to whether or not there is a RICO issue. Yes, yes, yes. Some of our employees in the Consumer Resource Center have actually made friends with a lot of vocal complainants, and that is a testament to the skills that they have. They are very, very good. They spend hours on the phone. They're excellent at handling people that come in, walk-ins and so forth. And just for some numbers, for fiscal year 2018, the Consumer Resource Center, as well as our neighbor island employees at the offices, received over 10,000 phone calls, just general inquiries. May or may not have dealt with RICO matters, but they handle each one so well. And if it's not a RICO matter, they will refer it to an appropriate agency or some other organization that could possibly help the person. It's very customer oriented. During those phone calls, if it is a RICO matter, they will spend the time to talk to the complainant about RICO and educate. So therein is our frontline education, the Consumer Resource Center, and the people on the front line in our neighbor island offices. We also have a website. So on the DCCA website, there is a RICO website, and there is a ton of information there as well. Over the years, RICO has compiled brochures, frequently asked questions, et cetera, about all the major industries that are regulated. And so they're there, they're downloadable. You know, you can read it, you can print it out, you can pass it out at meetings or whatever. But we do have all of that available through our website. The other thing that RICO does in order to educate sort of the public and licensees, et cetera, is that we interact directly with public at community events, at community fairs, and so forth. So in fiscal year 2018, RICO attended events where there were more than 60,000 people there. We normally have a booth. We have employees that are there from CRC or investigations if people have more questions about our investigative process. And of course, we have our brochures. Just recently, we attended the Kauai Elderly Fair. It was held several weeks ago, and it was such a success. The RICO employee that attended the event said that there were just so many seniors who had never heard of RICO, number one, which is, we have to work on that. So they had never heard of RICO, but when they talked to the people at RICO and the other representatives from DCCA, they were very impressed. They walked away with information in hand and feeling empowered. They were like, wow, you know, this is really, really good. And their family members agreed too. So it was such a success. And those are the things that we want to do. We want to get out there. We want to get into the communities. We want to let people know who we are. And that's the way we do so. And also in my role as the Complaints and Enforcement Officer, when I hear of a case where, you know, unfortunately a consumer has been scammed or has lost a lot of money, did all the right things, but relied on the wrong person, I often will make a personal call to that complainant and say, hey, is there anything that our office could have done to perhaps help to prevent that? Be it come and talk to you, talk to your friends, come to your church organization, or what have you. So we are here and we are willing to do that. And in fact, if any of you in your industries have an annual meeting or what have you, and you would like someone from RICO to come and talk to you about what it is that RICO does, we would be more than willing to do so. So please remember that and send me an email or call my office. We'd be more than happy to set up something. The other enforcement tool that we have is complaints processing and prosecutions. They go hand in hand. And as members of a board or commission, this is how you will be interacting with RICO the most. Okay. As I said, in fiscal year 2018, we processed 2864 complaints. That means after the complaints came in, the 911 calls to CRC came in, they were screened, and there is enough indicia of a potential licensing violation in 2864 complaints, basically. What CRC does in that particular scenario is they will refer those complaints to our field investigation section, and the field investigators will get it and do the investigative work, do the heavy lifting. So with the criminal analogy, the field investigators are like the detectives, okay? So they'll go out there and see whether or not there's a licensing law violation. Some of these cases may result in prosecutions, but most of them aren't. And that doesn't mean that RICO's not doing their job. You know, what that really means is that the majority of people in your profession are good, and they're doing a good job. And they really, you know, you guys have great people. So it's really a minority that we're dealing with, and that you guys will get to know my office is the minority of people who do run afoul of the law, and who my office will look at and consider prosecuting if we have the goods, so to speak. Okay. Some of the challenges, of course, with complaint processing and prosecutions, again, it's the numbers. It's the whole workload issue that is representative of any state agency. Prosecutions are the actual enforcement. So when the complaints come in through the Consumer Resource Center, they are investigated by the detectives in the field investigation section. At that point in time, if the investigator feels like, you know what, there's enough here of a potential licensing law violation, we're going to refer it to the legal section. Legal section, the lawyers will take it, they will look at it, they will scrutinize it, because RICO has a burden of proof in these cases. RICO has to prove by a preponderance of the evidence that there was a likely probable licensing law violation. That means looking at all of the evidence, documentary evidence, testimonial evidence, credibility of both parties, including the person that filed the complaint. So that is what the lawyer does. The lawyer analyzes all of that. And if they feel that there's a potential licensing law violation, then they will visit you in the form of a settlement agreement proposing disciplinary action, and that will be presented to you to make a determination on. The other way is to go through a contested case proceeding, which is an administrative trial, and the result of that will be the hearings officer's recommended order, which you will receive, and you will be able to act upon in your role as members of the board. The challenge for the prosecutorial process, again, it is always the numbers. And what I mean by that is a contested case hearing can take a long time. It can take a long time. It is like any other litigation. It involves everything from gathering to opening statements to putting on your evidence to cross-examination to filing of motions, putting on closing arguments, etc. All when the licensee also has an attorney as well that is fighting this tooth and nail. So it's really the numbers, because one contested case can sideline an attorney for weeks, if not months, and that means it just backlogs, okay? It really does. Nevertheless, the team is committed, and they try their best, and they get really, really good results. You, members of the board and commission, you guys are the judges. It's a difficult situation to be in, too, because you don't see the case. Okay, so unlike a judge that will have a case that's tried in front of them, you actually don't see it. By law, you have delegated that function to a hearings officer. So when the hearing officer hears the case, they end up writing a recommended order to you, and that is what you will see. You will also see a settlement agreement. Just like in a civil proceeding, the parties can agree to settle the case. It doesn't contain all of the facts. It just contains the critical consideration that went into the settlement agreement. And again, settlement agreements can unwind at any time, and it could lead to a trial. Therefore, what is presented to you as board members in a settlement agreement is just enough to give you an idea of what's going on, because if you reject it, it might have to go through the contested case process, and then you would see that case again. Okay, so I know and I understand and I acknowledge that I hear from board members that it's so difficult to make a decision on a settlement agreement because there's only manini facts. right? How are we supposed to do that? So in some ways, our office is asking for you to trust us and trust our judgment. Again, the attorneys are good. They work really hard. They consider an incredible amount of factors before deciding to resolve a case by settlement. And they also look at how similarly treated facts happened as well, the result, and also they compare it to other things as well in order to present a settlement to you. So you will see a settlement agreement, or you will see a hearings officer's recommended order in your capacity as board members when it comes to discipline. The things that I would like you to just remember when it comes to discipline is that the complaints do vary. So although you can put them in a similar universe, every single one is different. There are always facts unique to each particular complaint, and the attorneys do consider that. The second thing to remember is that there are a variety of disciplines that are available. The majority of disciplinary actions that you will see are monetary fines, but there are also cases in which, the more serious cases, in which RICO would be proposing to either suspend or revoke a person's license. There can also be situations where the licensee will be obligated to do something affirmative, such as maybe take an education course, or they may be subject to probation, and the board may end up monitoring certain terms to make sure that they comply. So really the universe of disciplines is pretty large. The attorneys work really hard to sometimes formulate that to the individual circumstances. I can tell you in all my years at RICO that it is rare that we run into what I say the evil licensee. Those are easy. We're going to go revoke your license. Most people kind of fall in the middle. You know, they make a mistake, or I didn't know, or they plead ignorance or whatever. So it's rare that we get evil. We get kind of a lot in the middle, and then kind of a lot like, oh my gosh, did I not do that? You know, sort of thing. So all of this, the disciplinary action that you will see will account for these variable factors that we see on a regular basis. The other thing I'd just like you to remember when you see disciplinary action in front of you is that it does not occur in a vacuum. Again, our office has to assure that our enforcement is clean, and that means that we have reliable evidence to count on in order to discipline someone. Regardless, and I have to admit, sometimes there are a lot of cases that we have where we're going to pursue enforcement action, and the respondents or licensees, you know, they're like, oh, well, whatever, I can pay the fine or whatever. Or they may not, or they may be out of town, or they may not appear, or what have you. Things are going on in their life and they don't appear. It's not a slam dunk for RICO. Okay, we still have to go through the hearings process. We still have to meet our burden of proof. And that's just the way it is, and that's just the law. Licensees are entitled to their due process. They worked hard. Each of you in this room know how hard you worked to get to where you are. They worked hard too. So they will fight tooth and nail in order to defend their livelihood and their reputations. Okay, so we make sure that we comply with the law. We make sure that due process is afforded. We make sure that whatever enforcement action we have, it will withstand scrutiny, especially on appeal. And believe me, they do appeal. And believe me, when they go through the appellate route, it takes years. It's like any other litigation, right? I mean, there's a couple of really young people in this audience, but I think most of us will remember that case from, quite a while ago that involved a pretty famous college football player who won the Heisman, went on to play professionally, became an actor, you know, was driving down on the freeway in the white Bronco, was arrested, was charged with some pretty serious criminal crimes. The trial took forever, was acquitted, then came all the civil proceedings and trying to enforce the judgment in the civil proceedings. That, and then all the other stuff that happened after it, the additional crimes and so forth, okay? Decades. And so I'm not saying RICO cases will take decades, but what I can say is they will not, believe me. But what I am saying is sometimes our cases can take a long period of time, and I know there is one right now that has bounced between the hearings office and the courts on appeal, and it just keeps bouncing back and forth. Okay, it is a hassle, but licensees have the right to due process, and they have the right to have an attorney vigorously represent them, and that's what they'll do. I'd like to just say a few things about how you, as board members, can assist RICO in the regulation of your various professions. The first thing I would like to say is that our greatest need from you and members of your industry is advisory committee members. An advisory committee member is like an expert in a lawsuit because you know your profession in and out, and you know it so much more than I ever will, or anyone in RICO ever will. We rely on your opinions when we have a case that is unique to your industry and we just can't decide what to do with it, or we need your expertise. They're called advisory committee members. They are appointed and they are immune from liability when they work for RICO and give us opinions. So one of the things that we always need is advisory committee members. We're in the process right now of renewing current advisory committee members, but there are a lot of people that are retiring, et cetera, so the numbers will go down. So I ask you to please consider being an advisory committee member. You actually can be an advisory committee member even though you are a member of a board. If the matter that you opined on ends up going through the contested case hearing process, then you would just simply recuse yourself from hearing that matter if it comes before you. But you actually can serve as an advisory committee member. Your identity is confidential. We do not let people know that you're working for us. I understand, small community, nobody wants to do it, but you know, we do. We basically protect your identity unless it's going to go to a contested case, in which case you're going to have to come up there and be a witness and give us the evidence that we need in order to prove the violation. If you know people in your industry that would be excellent advisory committee members, then please contact your executive officer, or you can call me at RICO, and we will get in touch with that person, because that is our greatest need. The other thing that you could help us in regulating your profession is in the area of education. And what I mean by that is just talk to people in your industry. Tell them that it's important to comply with the licensing laws. Tell them, do you know what the licensing laws are? And if you don't, this is RICO's website. Here's some brochure, read it. You know, you are a representative of your industry, and you hold a lot of power. So whenever you see them, talk to them. Several years ago, I had an acquaintance who was a member of the board, and whenever I saw this person, I remarked that I never really see any complaints from your particular industry. Why is that? And the person basically said that they self-regulate. They know before we ever will what's going on in the community. And so when they hear something is happening by a particular professional in their community, they're like on it, and they're there. And they're there to provide support, and they're there to provide guidance, and et cetera, et cetera. And so that's the reason why we didn't see a whole lot of complaints in that particular area. You guys hold that ability as well. So I would strongly suggest that you guys just get out there, network in your various industries, and tell them that it is important to know the licensing laws and to comply. The final thing that you can do to sort of assist in the regulation of your industry is be the best that you can be, you know, and by that I mean know the licensing laws in your area and comply with them. We have a lot of cases every single year. People call them technical violations, but they are nevertheless violations of professionals who don't renew their licenses on time, or they're not updating their addresses in a timely manner, or they haven't taken their CE courses, just technical things like that. Okay, we can and do take disciplinary action in those cases, but you as board members, you should be above that. So know when your deadlines are, and please comply with them, and tell everybody in your office and in your industry to do so. As a board member, you are up there on your profession, but you may also have a target on your back. They're just people are people. People may be jealous. People may be spiteful, what have you. So you need to be above board, know the licensing laws, and comply with them. It's just like being the subject matter of a lawsuit or the subject matter of a complaint. It is very, very stressful. Even though there may be no wrongdoing and no fault on your part, it is very, very stressful just to go through the process. So try to avoid that. Be in compliance. And I do have to tell you that as a board member, if a complaint is filed against you, you will not get any special treatment from RICO. You will be handled accordingly like any other licensee. So be the best that you can be. And as a matter of fact, that's why you guys are here in this room, because you guys are at the top of your profession. You do have standing, and use it for the benefit of your industry. And the other thing I'd like to say is, yes, last fiscal year, RICO imposed about a little over 400 legal actions. Okay, so the funnel, right, 2698 just for fiscal 2018, 2698, down to 400 legal actions. So a lot of the cases are disposed of here in the middle. 400 legal actions is substantial, but that's nothing compared to the 166,000 plus licensees that are out there. In other words, I think we need to tell people that people in the professions are doing good. You know, they're serving the public the way they are supposed to. You know, and that's a good thing. 400 from 2,600, you know, you guys are doing a good job. So I want to thank you guys for that. I thank you for your service. I look forward to working with you guys in the future. Thank you.
Board members, I'd like to introduce Senator Roz Baker. She is the chair of the Committee on Commerce and Consumer Protection and Health. And you will, if you are interim members, will have to come before her committee to be actually confirmed by the Senate. Okay, so for some of you who are interim members, Senator Baker is someone that you will soon meet.
Oh, that sounds so scary.
No, not that.
Aloha and good morning. I thought that I would give you a little bit of a taste of what may be coming if you have not come before the committee to be vetted before the Senate confirms you. So first of all, mahalo for all of your willingness to serve and for your service as a board member. Our board and commission members serve an important function. You really assist in the functioning of our licensing laws. And without you, we have both licensee and public members as part of each of the boards. We wouldn't really be able to function to make sure that the licensing laws are upheld and that our professions are treated appropriately. You are all governors, appointees, and the Senate has the sole responsibility for confirming governor's nominees from the Supreme Court all the way to all of our boards and commissions. We treat governor's messages like a bill. That means it gets referred to committee, we hold public hearings, we write a committee report. It's the committee report that takes it to the floor of the full Senate, and then we take a vote on advise and consent or to confirm nominees. Most all of the boards and commissions that are under the DCCA come to my committee because my committee jurisdiction is commerce, consumer protection, and health, which means I have the committee that I chair has the jurisdiction over items in DCCA as well as in the Department of Health. So if you have not been before the Senate to have your nomination confirmed, this is what you might expect. My committee will ask the nominees a few questions. And all of their answers will be shared with the other members of the committee. I personally contact each board member to make sure that they're interested in serving and to explain the process. I also want each nominee to not have to contact all of the members of my committee. So I can vouch for all of the nominees with my committee members, and I can say that I have a really pretty good track record. I don't know that anybody has been turned down if the chair of the committee has recommended advise and consent. Prior to contacting each of the nominees, we'll schedule a date for the hearing. My committee room is 229 on the second floor of the Capitol and the Eva Malka wing of the Capitol, so right upstairs. Unfortunately, we want everybody to attend the hearing, but because it's set on my committee's agenda and my committee's schedule, sometimes people cannot attend, and that's okay. We'll ask you to do what we ask all of the ones that will be in attendance, that is to give us at least 3 letters of support from friends, family, colleagues, to say, you know, this person is a really good person, knows the profession, will be a great board member. Whatever they want to say positive about you. Because we want that supportive testimony, because we want your tenure as board members to be successful. We use that testimony when we write a committee report. As I said, we treat governor's messages like a bill. So we have to have testimony on the item, the nomination. My staff will take that testimony, write up a committee report. The committee report goes to the full Senate, and that's really how the rest of the committee, the rest of the senators have a contact with you and know who they're voting on and why we've recommended. So each one of the nominees in that particular committee report have a little synopsis of what your background is, what your qualifications are, and why the committee recommended to advise and consent. Once they come to the floor, the full Senate votes. The recommendation is to advise and consent. Once we pass the vote on the Senate, you are officially confirmed, and governor or somebody from the executive branch will swear you in. It's an open process, so we let everybody know when your nomination is going to come to the floor of the Senate for a vote, and we welcome you to be in the gallery that day with any friends or family that you want to have. I know the process can sometimes be a little bit intimidating, and we certainly don't want it to be. I try to be as friendly as I can be when I'm talking to you on the phone, explain any questions that you have. And my committee is really very grateful for your willingness to take the time and effort to be part of the boards and commissions system, because without you, our licensing laws and some of the other functions that we have in government would not work as well as intended. So that's part of how we engage professionals as well as members of the public in that process. If you ever have any questions as you're preparing for your confirmation hearing, don't ever hesitate to call my office. I have a staff dedicated to working on the boards and commissions. And of course, if I happen to be in the office when you call, I'll be more than happy to speak with you or get back to you. Also, can communicate with email whenever you have an issue or concern, and maybe it's just easier to shoot off an email in the middle of the night rather than disrupt your workday by trying to get a hold of me. I would be happy to answer any questions that any of you might have either now or afterward. But again, thank you very much for your willingness to serve. Thank you for making yourselves available to be part of this process, because it really will help to advance your various professions. Mahalo.
How's it? You know, what do you call? I'd just like to echo what the senator said and express my gratitude and appreciation for all of you serving, and particularly after hearing from RICO, I'm still amazed you still want to serve, actually. Oh my goodness. She put the fear in you. Come on, as Esther said, that side of the shop is very few and far between, and again, it goes to show you how the industries really, in many respects, self-regulate themselves. But let me just say this. As Senator said, she confirms all of your nominations that's sent down by the governor. The House is not that part of it, but of course, we hear all the bills that impact on your industry. And I've been chairing the Consumer Protection Committee for the past 2.5 years, and prior to that, I chaired the Education Committee for 15 years. And I can give you an education example. 30, 40 years ago, when there was an opening for principals, maybe 20 or 30 people would apply for it. Today, if there's an opening for a principal, there are times when no one applies for it. And it goes to show you that there's not that many people willing to step up and get into a leadership position. And this is for a wide number of reasons, but you, all of you, decided that you would take on a leadership position, and actually you're not getting paid to do it too. You're doing it as a volunteer basis because you want to give back to the community, and you should be commended for that. So the bills that we hear both in the House and the Senate, I know, Senator, I can speak for the Senator on this, we really depend and rely upon your expertise. When there's a bill that impacting on beauticians or elevator mechanics or electricians or whatever the industry might be, your voice and your perspective is very important. Now, we hear from a lot of stakeholders, and not everybody at times agree with each other, but your voice, and because you're speaking from your board or commission perspective, it means that the position was vetted, it was discussed at the meeting, and so whatever decision you come up with is a reflection of a consensus as opposed to an individual coming with a personal opinion. So don't think your voice doesn't count, because it really does. And once again, thank you for taking the time to do this. I know it's really a labor of love, and I hope to see some of you at the hearings. Thank you.
Thank you, board members. That concludes our orientation, and I do want to thank you for your willingness to serve. It is difficult. I think I heard someone from the governor's staff today indicate that there's about 127 vacancies. So like Esther is looking for ACM or advisory committee members, we are also looking for board members. So if you can reach out to your colleagues and tell them that it's really not that bad a job, that for them to, file applications with the governor's office, and then so that we can vet them and have them participate in this government process. We're also looking for public members. So say you are done with your tenure as a licensee on a particular board, you could always come and be a public member on another board. So, we are actively trying to recruit public members. So if any of you are interested, or if you know of people who may be interested, please reach out to them. You can let us know, or the executive officers know, and we can then forward that governor's application that's online now to them. So, on behalf of DCCA, PVL, we want to thank you for your, attendance today, and also for your, willingness to serve the public. Thank you.